All right. Thank you all for coming in today. Appreciate it. Today is March 4th, March 4th, 2023. It's Saturday. All right, I believe you guys can all hear me. Looks like my mic has some response from this microphone indicator. I'm going to go ahead and remove the chat for today so that way we stay focused on today's subject. And once we get into our normal day-to-day or every Saturday routine of Q&A, I will enable that again. So before we take your questions pertaining to your particular class tier, whether that's freshman, sophomore, junior, or senior, the first half of the class pertains to debt discharge only. Okay, so we have our studious student by the name Miss Tanya of the Stalwart Holdings Express Trust. She's out of San Diego, California. She's here with us today, which I'm very, very, very proud of. She has an excellent victory, and she's going to share with you all her experience of the debt, what she submitted to begin challenging the banks. We have actual recorded footage to share with you guys to show you how that went down. So that's going to be great. You don't want to miss that. Following that conversation, Tanya and I will be taking questions from everybody pertaining to that information. She's really going to be the co-host here for today. So that's pretty cool. So before we get into that, I got a few announcements for you all. Just a reminder to all of our private clients, you do have another Zoom meeting with me on the 15th to discuss anything that you want, okay? Now remember, in addition to your Express Trust packet, you get to choose one area in which you'd like to express your trust. It could be taxes, debt discharge, court cases, quit claiming property over into the trust, a marriage trust bond, meaning between husbands and wives. And that's important too, because you want to get rid of that marriage license, okay? Maybe you have a foreign trustee who needs assistance in coming to America. Whatever you want, you get to choose one area to express the trust, and we will help you with that. And that's in addition to your free once-a-month call with your representative who is working on your file. Now, announcement to all Patreon members. All right, please do not confuse yourself as a private client. That is only for those who are contracted with us. And of course, they've paid a much higher tier segment. And so that depends on the tier level that you're in if you are a Patreon member. That's going to determine what information you have access to. So please understand, I did get some questions over the past couple of weeks that some of you have some issues with logging into Patreon. It's a third-party service, so that is outside of my scope. I have no control over it. I do know that Patreon went down for a time, but it is now back up. So if there are any technical difficulties, you want to reach out to their customer support. Even with billing issues, you want to deal directly with them and they will help you with that. Please also have your browsers updated. Okay, that's very important. I recommend Chrome, Firefox, Opera, or Safari. If you keep those updated, you should be okay with having access to the video footage. All right. Lastly, all of your questions submitted in Patreon, they will be answered directly in Patreon messages, or you can wait until the first Saturday of the month and we can talk about them here live with everybody to hear the responses. So I can assure you all of Saturday's classes in the past have the answers that you're looking for. It is a lot of information. If you could be patient, full comprehension will eventually come to you for sure. And everybody's different. Everybody's dealing with different counties, different cities, different states. We call them countries, and they're doing their own thing. So you have to take this information here and apply it by trial and error in wherever you are in your jurisdiction. You may find that it's a little bit different than how your peer got the same remedy, but overall it's the same thing. So don't give up. All right. This week we will be uploading version 2 of the sophomore class. That's going to be going over obtaining your estate and your trust enterprise EINs. Very, very important to set that up before we get into start talking about the drafting of all of your documentation for your internal trust file. Some of that documentation is going to be sent out to the local authorities, such as the county clerks, sometimes even in the courthouses. But you want to get that estate and trust enterprise EIN established first. And we're also going to be going over how to open up a personal trust account. Okay, those of you who are already in that system within the sophomore class, you know that we established and put together a second trust that is going to be your bridge between the foreign and the domestic. Banks must have a personal guarantee to do banking here in the United States. There's no way around that, unless you have your foreign trustee who's going to come here and provide their visa number in lieu of a social to open up the bank account. You do have that option. But if that's not possible for you, then you need to understand how to protect yourself under the laws of TEFRA using a personal trust account to handle your day-to-day banking, and even how to set up a business trust account if you have an existing business such as LLCs or corporations. You can set those entities up as the trustee to those trust enterprise accounts. All right, so let's get into it. I'm going to search for Tanya here. I know she's here with us today, so let me find her. There we go. Oops. Let's see. Tanya, are you with us? Can you hear me okay?
I am here. Hello.
Awesome, awesome. Thank you for coming in and helping us all to be a part of your journey. And
I'm so excited.
It is awesome. It really is. It really is.
Mm-hmm.
So just tell us, you've been with us for almost a year now, or a little over a year?
Yeah, I think so. I started, I think probably like mid to late 2021, I think.
Mm-hmm. Mm-hmm.
Yeah, so, and I was able to file my trust in December of that year when I got all the paperwork together.
Awesome. Awesome.
So it might have even been longer than that. I'm terrible with time. But yeah, so I started with just starting to send the checks as you have described and stuff in the sessions and stuff, and I got myself stamps to just make it easier. And I was trying to do the treasury checks along with it, but after a while I had to choose one or the other because I couldn't afford to continue doing both.
Exactly.
Yeah, so I continued to send the checks and stuff, and I sent the original dispute letter. And of course, I didn't get any kind of a response to that after 30 days or so. And then I sent the accounting letter, didn't get a response to that at all either. And then at that point, it was a matter of me just waiting until I could afford the filing fee for the court case. So, I mean, I probably did, let's see, I think on my filing, I probably had like a good 6 to 8 payments for the loan that I did. Now, I mean, to start off with, I had a bunch of different loans and I have a mortgage and things like that. And so I was trying to choose to see which one I did. And I decided to start with this particular loan that was unsecured for about $25,000. And the balance of it at this point is only like $23,000 or something like that. So it hadn't gone down that much. And it was my largest monthly payment. So like $810 a month. So I figured if I was going to start with anything, I'll start with that because that's going to provide the most relief to me on a monthly basis. And I can use that money towards additional fees and stuff to get rid of the rest of the loans. So during this whole time, though, I have sent dispute letters to all of my loans in the process and the accounting letter. And so while, you know, I'm able to send in do the next step, like 30 days after that, you know, I've decided I've got to focus on kind of one at a time to make sure that I just feel like I've got the process down.
Right.
So I went ahead and did that. So with this one, and then I did the bill of complaint and I reviewed that and I edited it and stuff like that. And there were still mistakes in it, as it turns out, when I got it back and stuff. But it's kind of nice to know that that didn't really affect the outcome, which was cool. So I filed the bill of complaint with the court for $435. I did that at the end of December 28th, actually. And I sent out notifications to the parties involved probably about January 10th. So I was a little bit late on that, but I did manage to send it. Mm-hmm. And then I just kind of waited. I wasn't sure if I was supposed to wait like 30 days from December 28th or 30 days from January 10th. But just because of my schedule, it kind of ended up extending out a little bit, I think, into February. And right around 30 days from around January 10th-ish, I started getting a phone call from an attorney that was representing the loan company. And I wasn't sure if I should pick it up or not. So that's when I started like messaging you and talking to somebody else on your team and stuff about it. And they were telling me, yeah, go ahead and talk to them. They probably just want to get an idea as to like where you're at, what you're, what it is that you're looking for and things like that. And that was exactly what the conversation was. And the attorney, as it turns out, was actually really quite nice. He doesn't have a personal stake in it. He's just representing his client. And so I kind of let him do more of the talking initially, just to try and get an idea as to like what it was he was going to be asking me about and what kind of information he needed. And my biggest anxiety was just like, do I know how to like explain this to him and stuff? Because I kind of know it conceptually. And while I've read through the documents, like I don't necessarily know verbatim with every definition of the legalese that's in a lot of the forms that you give us, as much as I try and understand it. And unfortunately, I don't have as much free time to be able to kind of dig into it as much as I'd really like to. But I kind of went with just what I know conceptually of what it is that I'm asking for in each one of these documents. That, I put on there that, this is, payment in full. I put my loan amount number on there. I did the stamp on the back. And throughout this whole process too, with the checks, every time I write a check, I take, I have my Genius app and I take pictures of the front of the check and I take pictures of the back of the check. I record like the date and time and stuff that I'm sending everything. The key to me, because I've got a lot of stuff that I'm trying to discharge, is to just stay super organized. So I've got like an Excel sheet and everything like that for it as well. Dates that I've sent things, dates that, due dates for them to respond, and so that I kind of know where I am in the process. And so I keep those documents and stuff. So then that helped me with the bill of complaint so that I could go back and take a look at exactly what dates, I sent everything, what dates they were cashed, and things like that. And so in speaking to the attorney, like his offer was like, well, what if, they just, he's like, I don't know if that's what they're going to do, but, what if they just give you $5,000? And I'm like, $5,000 with the loan still in place? And he's like, well, yeah. He's like, maybe. I'm like, no, that's not gonna fly. I'm not gonna take anything less than a complete discharge of the loan. It's like, okay. He's like, well, let me go back to my client and see. So it was an interesting conversation. And as we, the more I spoke to him and stuff, the more confident I felt about discussing the case and stuff. And I really just tried to keep the things that I was saying to a minimum and only really relative to what I was trying to get out of the case, apart from just like trying to create a friendly enough rapport that there was no like battling about it. And there really didn't need to be either. So it was kind of nice. And so, it went back and forth and initially, because the bill of complaint, requests that they not only get rid of the loan, but that they also reimburse the payments that they accepted during that time, that they cover any other miscellaneous fees like the filing fee. And then there's also like a penalty of like 2 times the original loan amount. And what I didn't do in the initial conversation when he was asking me what I was looking for is I didn't list all of those things. And, basically I said, well, bare minimum, I just want to discharge of the loan. So I kind of tried to backtrack a little bit during next conversations to see if I could just at least get reimbursed for the payments that I made, because, I was asking him that I also wanted to make sure that I wasn't going to get, that I wasn't going to have to count it as income, as a reporting to the IRS, and that I wanted to make sure that my credit report was clear, that it was reported as paid in full. And when he came back, he said, well, we can't really say paid in full because it wasn't really paid, so technicality. So I think next time I might say, that's satisfied, fully satisfied. So that might be a way that they can do it.
Right.
But they agreed to take it off my credit report
that's
entirely.
Exactly what she's talking about.
Yeah.
Yeah. She's viewed the information that's all available to you guys as far as recording satisfaction. And it's very similar coming from the Uniform Commercial Code, which is codified in every state. So I don't care if you're in New York, Boston, Massachusetts, or in California, it's all going to be uniform. The order process is you must send that bona fide dispute first. You have to let them know what is coming. Now, it's easier when you send that letter. Of course, like Tanya said, they're not going to respond. Sometimes they do, and it's not going to be the response that we're looking for. but they stay silent. And that just means they acquiesce, and they're going to go ahead and either accept your draft that you send in the mail, or they're not. And in most cases, they're going to accept it on the first round. And what we like to do is do it for the first month, second month, and the third month. So that way you have 90 days where you're into this thing. They've accepted an actual contract. Now, by them not closing out the loan automatically, that is a breach of contract. From there, they knew without telling Tanya that we've just entered into what's called, she can use statute of fraud against us, statute of limitations of fraud. So that bona fide dispute letter will start the clock. I believe in California, it is 4 to 6 years that you have to do battling in court over this thing, and they knew that. So you went into what's called arbitration, which is very peaceful. We have the recording, and we're going to play that for you guys to show how that went. It's a 2-part recording, very short. The law office, his name is redacted, and same thing with Tanya's last name. So this is going to be very good information. Before we play the audio, any final thoughts you'd like to say, Tanya?
No, I don't think so. I mean, it was a lot easier than I thought it was going to be. So, I mean, I'm definitely feeling a lot more confident going into, the next case and stuff. So
it is a definite confident builder for the next one.
Mm-hmm.
If this is going to work for, and this type of loan that we're talking about here for you, that was for, what was it, a HELOC secured by property?
No, actually, this was just an unsecured loan, a regular unsecured loan. Yeah.
Okay. Yeah. So there's a lot of us here that are dealing with different types of loans, but this works for all types of loans, all types: student loans, auto loans, personal loans, HELOCs, unsecured debt, mortgages. All of that is considered game here. I'm going to give you guys all the tip. We've talked about Title 15 USC 1635. And that law is basically saying, if they haven't given you the proper rescission forms in the very beginning on closing of escrow, you're supposed to have these forms just in case you want to rescind the contract within 3 days by midnight of consuming this loan. If they don't give you those rescission forms, you now can ask for the loan to be canceled, and you want to give them at least 20 days to refund you all of the monies that you put down on that collateral. A lot of times they're not going to do it. But I use that as my reasoning for why I'm issuing an accord and satisfaction. This is what you call going into failure to disclose properly information. If you're not properly disclosed, then you have a fraudulent contract. And so we know that they're not going to just cancel it off of that fact. So we just say, look, this is what happened. You didn't do this part. So I'm going to help you prevent irreparable injury going forward in the future by giving you an accord and satisfaction payment. So that way there's no dispute by the time you go to court as to why you're doing what you're doing. You're not trying to defraud anybody, even though they've defrauded us, of course. But it now makes sense, and you don't seem like that crazy person who's categorized in that field of, oh, this is just sovereign citizen stuff. This is just secured party creditor stuff. We don't want any of that. So this is a definite confidence builder. I'm very, very happy for you, Tanya. Very happy. So let's get into it. I'm gonna go ahead and meet you out, mute everybody, and we'll.
Hello, this is Greg.
Hi, Greg. This is Tanya Clearwater. Just giving you a call about the lending point case.
Yes. Hi, Mr. Wall. Thanks for giving me a call and following up with me. So,
Sure.
as you might have heard of. I'm sorry. Can you hear me?
Yeah, can you hear me?
Yeah, I can hear you. I didn't mean to interrupt. What were you saying?
Oh, no, I was just saying, hopefully your emails are working again.
Not quite, but I think they're close. So we do have a sort of workaround that we've been able to use. I just don't have my normal level of access, but I appreciate that. So yeah, the reason I had originally called, and as I said in I think I left a voicemail or two, was we were recently retained, my firm was recently retained to represent Lending Point in this case. And, we've gone through the complaint and some of the documents, but I think it would be helpful if you could, I guess before we get into any details, let me just confirm this with you. Are you representing yourself in this case? You don't have another attorney working on this case, is that correct?
There is not an attorney, no. I'm representing the trust.
Gotcha, okay. Just wanted to make sure, because otherwise we're not technically allowed to talk. But if you're representing, if you're the one that's representing the trust, then it's all good. So we went through the complaint and some of the account documents, and I think it would be helpful if you could just sort of give me a quick, 1 minute high level sort of overview of what the claim is here and what the issue is.
Mm-hmm. Well, I mean, I sent a dispute letter to Lending Point some time ago that they never responded to, requesting that they provide basically proof of the fact that that I owe the loan and that I'm continuing to having to make payments to them, which they never responded to that. So that was why I ended up filing the breach of contract, because I was a part of the accord and satisfaction process, and following the California state law about that. And they collected the payments and they taxed them, even though they had the accord and satisfaction verbiage on it, which, it was stated that in accepting that it would, that it would basically address the whole part of the loan. And
okay.
The response, they never responded to that. And I even had looked at what their assessment of the balance of the loan was, which they also did not respond to. So hence the breach of contract.
Okay, gotcha. So you, as part of the loan payment, you sent in checks that had a payment amount, and then you had written full accord and satisfaction on it. Did I hear you correctly?
Yeah, it wasn't exactly what it was worth, but yeah, for a full payment of and settlement of that loan, payment in full satisfaction.
Okay. And what was the checks that were sent in with that note on it? Was it for the full amount of the loan, or was it for a lesser amount than the full?
It was for a lesser amount than the full. So I continue to make payments with the verbiage on it.
Gotcha. Okay. And so I know that in the account documents, well, let me ask you this first. So the document that was attached to your complaint, a letter dated May 27th, 2022, that's the dispute letter that you're referencing?
Yeah.
Okay, thank you. I appreciate that. And so let me ask you this, because I know that there was another dispute that was made with Lending Point around the same time related to an automatic payment, and I believe that your request was to perhaps rescind the automated payment withdrawals, and you were going to make individual payments going forward. Is that, or something to that effect, is that related to this, or is that a separate issue?
That's a separate issue.
Separate issue, okay. So in other words, what's alleged in the complaint here doesn't have anything to do with that dispute referencing the automatic withdrawal. Okay,
correct.
Understood. Okay, so the way that these cases tend to go, and the way that my client likes to sort of approach these situations is when a new case comes in. We like to reach out and talk with the plaintiff or plaintiff counsel as applicable to see if there's some sort of, potential resolution that could be made before we get into filing responses and discovery and fighting about it and all that. We always try to see if maybe there's something that can be done on the front end to where, we can fully resolve this and, kind of wrap it up without having either side having to devote a tremendous amount of time and expense and resources to it. So, my client has authorized me to make an initial opening offer. Is this something that you're interested in? Potentially talking settlement?
Yeah, certainly. I mean, I'm willing to take it to court, but if there's, an appropriate settlement that can be done, privately with fulfilling whatever things appropriate to for the case, and that's fine.
Okay, excellent. So, well, let me ask you this. Did you have sort of a goal of what you wanted to get out of the case? Are you looking to have like a certain amount of money paid? Is there some debt forgiveness? Is there something that you had in mind, perhaps?
Well, certainly what's being requested is that they honor the verbiage on the checks and discharge the debt. I mean, if I take it all the way to court, then there's also the penalties and stuff that can be awarded for that. But I think we have precedents that, we'd be able to follow through with that. So, I mean, I don't know what your offer.
Sure. So, if say that Lending Point offered $5,000 to just settle the case in full, but the debt would remain intact. So a $5,000 payment, the debt remains intact, payments continue to be made. Would that be something that you'd be interested in?
Are you talking about changing the balance to $5,000, or are you talking about keeping the balance at the 26 and offering a $5,000 to cash out or something? I'm trying to understand what
essentially the second one, keeping the whatever the current balance is today on the loan, keep that as is, and then Lending Point would make a $5,000 payment. If you wanted a check for $5,000, I'm sure that could be arranged. If we wanted to do just a straight $5,000 credit on the remaining balance, I believe that could also be arranged. I have to check with my client to confirm, but
no, I'm for full discharge on this loan at bare minimum.
Full discharge. Okay. So
yeah.
Well, let me ask you this.
Payment, so no.
Okay, got you. So, and please understand, I'm not officially putting this on the table at the moment, but if I was able to convince my client to forgive the remaining balance of the loan, would that be sufficient to resolve this matter fully?
I mean, so long as it came along with, showing that the loan is being paid in full on my credit report, that I'm not going to have to worry about anything coming back to me later or taxes or anything like that. I mean, it's something I would consider.
Okay. All right. Well, let me speak to my client, and I will talk about talk with them and see what they want to do. And I'm still having a little email trouble, so I can't guarantee you I'll be able to get a hold of them today, but I hope to speak with them in the next day or two and then follow up with you. So maybe we can continue this discussion after I've had a chance to talk with them.
That would be great. Yeah, let me know.
Okay, excellent. I'll do that, and then I'll plan to give you a call hopefully sometime later on this week, maybe Wednesday or Thursday, and we can hopefully pick the conversation up at that time.
That would be great. I may end up having to try to speak, but I'm not sure just yet. I'm hopefully going to sort that out today. So.
Okay, sure. Gotcha. Gotcha. Well, understood. And I'll talk to my client. And just to be clear, the offer that I said is not. I don't have authority to officially put that on the table at this time, but I'm going to talk to them about it, and I'll let you know what they say.
Okay, sounds good.
All right. Thank you, Mr. Ross. I hope you have a good rest of your day.
All right.
Have a good one.
All right. Let's go to part 2.
Oh, this is great.
Hi, guys. This is Tanya Ross.
Hi, Mr. Ross. How are you doing today?
Yeah.
I'm good. So, as I had mentioned in my email, I spoke with my client, and they authorized me to put an offer on the table to resolve the entire case of I'm sorry, I just had a blank. The offer is full forgiveness of the debt, and they confirm that that would include no negative reporting of the account going forward on to any of the credit bureaus.
Okay.
So
No negative.
anything.
Sorry, go ahead.
I was just going to say, and in exchange for that, we would request that the case be dismissed with prejudice, and that you and the trust enter into the trustee, being the plaintiff in the case, enter into a settlement agreement that releases the claims that have been asserted. Just wanted to make that clear.
Sure. So when you say no negative effects, are you saying that it'll be marked as or noted as paid in full?
I believe so. I can find out specific details because there's a lot of different options on the way it could be reported. But if you're saying that you would like for it to be reported in that way, I can take my we can try to work that into the settlement agreement. The sort of specific language regarding the reporting, it being whether paid in full or there's a lot of options, and so yeah, I think we can make that happen. Is what I'm saying. Yeah.
Okay. All right. Yeah. So if we can get that recorded as paid in full without prejudice, and just so not only can I not come back for anything, but neither can they. I don't know if we can put some language in there in terms of like taxes and stuff like that that they can't come back for any of that. And then we can also have the case that it just stays a private matter. How does that sound?
Okay, so let me just one question. When you say that the case stays a private matter, what do you mean by that?
Just that if you want to keep the records so that they're not publicly available.
As in like the settlement agreement, is that what you're referencing, or
Yeah.
are you? Okay.
It's just a decision anyway, but I mean, I'm just covering bases.
Yeah. I mean, we would include in the settlement, I think the standard language that we use is that the settlement is confidential and it can't be disclosed except in a limited amount of circumstances. But okay, well that sounds great. I think so. Just to recap, the deal would be the debt is the account, the remaining balance of the account is forgiven in full. There would be a reporting going forward related to the account that says that it's been paid in full. And then there would be confidentiality of the settlement amount of the settlement agreement. And then, did I miss anything? Or is that?
So any tax issues and things like that none of that can, that they don't have the ability to come back to request anything.
Okay. When you say they, you mean Lending Point?
Yeah, Lending Point.
Okay, gotcha.
Yeah.
Okay, yeah, I think so. As far as the
tax, you know what I mean?
I'm sorry, you're breaking up just a little bit. I think it's my cell phone sometimes gets bad service. Could you just say that last thing a bit for me again on the taxes?
So that once the debt is forgiven, it's not reported as income for me and therefore owing taxes on it. So that's what I mean by not being able to come back to me for any tax back once the debt has been discharged or forgiven.
Okay, gotcha. I will. So all right. So with regards to the taxes, the way it works, and frankly, I might need to just look into this and follow up with you. But I don't think this is something that could hold up our deal or anything. But the debt forgiveness, I understand, is considered income. And I need to check to see what the reporting requirements are for Lending Point with regards to that. But I understand what you're saying, and there's that we normally have standard language in our settlement agreements that addresses the tax implications. So I'll look into that, and just because frankly I haven't dealt with a lot of situations where the payment or the consideration for the settlement is debt forgiveness as opposed to the payment of money. So I'm just not familiar with that situation, but I don't think that'll be something that would hold up the deal. And I think, I'll work that into the settlement agreement as necessary. And then I think I'll aim to send you a settlement agreement that reflects these terms. Hopefully by the end of the week or maybe early next week, I got to put it together and then get final client approval for it. But I'll do that. And then in the meantime, I know that there is a response deadline coming up for Lending Point to respond to the complaint. And I will want to file. Usually what happens in these situations is we can just file a notice of settlement with the court, which signals to the court that, the parties have reached the step negotiating the final terms of it and, crossing T's, dotting I's, putting signatures on and all that. And that, once it's complete, then we can do a stipulation of dismissal with prejudice. But I will speak to the California counsel who is admitted in California and see if he needs to make an appearance to file that, or maybe you could just file it. I'll follow up on that point. But
what for that deadline?
So the response deadline for Lending Point, I believe we were served on January 25th, and then it was 30 days. So what is that? February 24th. Okay. We got 9 days. So the only thing we would need to file before then would be the notice of settlement. And at that point, we would be fine from there. So, but I'll work on that on my end, and then aim to send you a copy of the notice when we send the settlement agreement.
Okay, great. Yeah, the quicker we can get it done, the better.
Agreed. And I appreciate your time today, and I'm glad we were able to find something that can resolve this.
Yeah, absolutely. Thank you so much for your help.
All right, absolutely. Have a good day.
All right, you too. Bye-bye.
Congratulations, Tanya. Congratulations. Wow. I'm so glad you recorded that. As you guys see, these attorneys don't know. They don't know. The banks know, and it was actually the banks who instructed this attorney on how to handle this, because going to court, that would have been a monster. I believe the National Banking Act of 1863 says that the penalties of what they've done in Section 33 would be, Tanya would get a complete full discharge, plus every payment back to her after the initial accord and satisfaction payment, and double the face value of the note from the last time there was a refinance with that particular bank. So if that note was initially, let's say $100,000, that would have been $200,000 in her pocket. So it's wise to go into arbitration and settle this thing here and now. I'm gonna go ahead and go back and unmute you, Tanya. So I think at this point, Tanya, the very last thing that we have to do here is just finalizing the settlement. So that way, either yourself or the attorney is going to file for dismissal in conjunction with the complaint. Is that correct?
Yeah, at this point, I'm still just waiting on the settlement documents from them. I sent an email just asking for an update. He was hoping to get it to me by the end of the week, but like he was saying in that call, he's got to talk with the client and get it approved and all that stuff. So yeah. Now the extension because when he first asked for the extension, because we were coming up to their response date, he originally was asking for like an additional 30 days.
Right.
And I was like, that's really, I don't know about 30 days. He's like, well, we could shorten it to 21. I'm like, how about 14? You get 14 days.
Yeah.
So they took the 14 days. So now their date is March 10th. So I'm presuming that I would get it before then to approve and stuff. And then I just need to know like what to file that says, that yes, we've agreed to a settlement and things like that. And, and he was trying to say that, well, if you keep going with this, they can drag it out. And, from what I've seen, we could probably prevail and, and stuff. And he's like, even though that there's things that we need to, have discovery for and things like that. And so my response to him was like, well, there is things that we're not talking about here and stuff. I go, and if I did bring this to court, it's not just about precedents. It's not just about writing letters, writing a statement on the check. There's more to it. And I go, and I do feel like I would win. I go, but I don't know if I want to take the time and effort and stuff at this point. So for me right now, like, while I would have gotten more money going forward with this, it probably could take, 3, 6 months, maybe even a year to probably get through the whole thing.
Exactly.
And right now I'm just focused on just reducing debt at this point, and I can look at building more wealth later.
Exactly. Take the win now, use that to empower, and use it to be stronger in the next case, of course.
Mm-hmm.
Yeah, awesome. So guys, let's reiterate. She started out with the bona fide dispute, right? It doesn't matter how long ago you've got the loan. It doesn't matter. We just said the rescission forms were not given to her. So that's going to be your excuse as to why you're doing this. Followed by the accord and satisfaction payments. Just look that up in your state. It's going to tell you everything that you need to do. But of course, in the webinar, you have a clear picture of what that bona fide dispute is supposed to look like. You'll tailor it according to your specific situation. You know exactly what to write on the front of the check, on the back of the check, and you will scan those for your own personal file before you mail them out, certified or registered mail. And you must include the registered agent when you start this process. Find out who your bank's registered agent is in their initial jurisdiction state. You must do that. It's called lawful due process. So after you've done at least 1, 2, or 3 payments on a monthly basis, you then move forward with a statement of accounting. Let the bank clarify to you under UCC 9-210 within 14 days to verify the balance of the debt after you've made those 3 payments. If they come back saying there's still a debt, okay, fine. We'll move forward with filing a bill of complaint in either Chancery or Equity Court. And that's going to vary depending on the state that you're in. California is Equity. Illinois is Chancery, all right? Pennsylvania, Chancery. Once you file that, now you've told the bank, I know what has been done, because they're expecting you to, they're trying to call your bluff, is what I'm saying. They're not expecting you guys to file a bill of complaint, to pay the fee and go the whole 9 yards with them. They're not expecting that. And when you have something like this, it is so powerful that a lot of attorneys don't deal with it, but there are a big handful of attorneys that actually use accord and satisfaction to handle a lot of criminal cases back and forth behind the scenes. So you actually had the opportunity to teach this attorney something here. As you heard in the beginning of the second part, he said himself he was just at a loss of words, and that they came back and said, we're going to do full discharge. How did you feel when he said that?
I was super excited. I mean, it really definitely let me know that the bank knows what's up. They're, and as much as he kind of tried to spin it that like, well, you're not going to get this offer if we go later, and you're not going to win if we go. It's like the only reason they would offer that now is because they know that I have a case. Exactly. They know it would be more trouble at the end of the day. Mm-hmm. So, and it really let me know that this process is definitely, they're not going to say it, but it's extremely powerful. And the way that they respond to it is what tells you, that we've got something in gold here. Yes. So it was just,
mm-hmm.
and I've been doing this process for a while, and it's been great, and I've been getting everything set up and stuff, but having this like kind of real life situation happen where like I'm starting to reap the benefits of this, taking the time to set everything up properly and mm-hmm. send everything in the right order with the right verbiage and stuff on it. I'm like, wow, now I know it actually works.
Yeah, I mean, accord and satisfaction is so strong without the trust, but when you add the trust with it and all of its elements, it sure does cut out a lot of the pain and suffering and all the processing down the road. Let's just skip everything and go straight to arbitration. Do you want to litigate or do you want to negotiate? In this case, they wanted to negotiate with you.
Yeah. So and next time I'll start with, asking for everything that's basically in the bill of complaint, so I can start the negotiation from there, saying, look, this is what I'm asking for in the bill. this is what I want. And they can come back and offer me less, and I can settle for that. But yeah, and I mean, my husband happened to mention it to somebody else, and they were like, "Well, I'll pay you if you can get rid of my tenants." So that'll be a separate conversation to have with you, I agree.
Oh yeah, I mean, that's what this is all about. You have to spread your remedy, all right? It's not just said by me or whoever I've learned it from. The best thing is if you have students that are doing this process and they're getting the remedy, that's all that matters to me. It really is. I think that speaks volume. So I do thank you for taking the opportunity to share that information with us.
Thank you very much for providing it. I mean, it is absolutely priceless.
Thank you. And like you guys, this stuff applies to tax bills as well. Especially that that the IRS is using it already. They call it the offer and compromise. And they're trying to take away certain elements of the accord and satisfaction process, but accord and satisfaction process is way better. So when they don't respond to you or they respond the same way, sue the IRS in the United States Federal Claims Court. Sue them. You can do it. The recent video on the tax injunction, there's elements in there that you can use in that lawsuit. You cannot be afraid of these entities. They work for you. Well, not the IRS, but the ones above them, they work for you. So let's take a few questions here. If any of you guys have questions for Tanya or myself, we'll take those before we get into our normal questions in regarding to the course. So you all can now raise your hand and we will start answering. All right. Let's go to Frenchie. How you doing, Frenchie?
Hi, everybody. Hi, Tanya. Congratulations.
Hello.
This is amazing. Everyone knows, but I hope to be the next one. I have court date Monday. And so I do have a question. Even though I know what to do, I know how to handle myself, that's going to be my second court date. So hopefully I get the remedy this time. My question was, because I did exactly the same process as you, for me, it's an ELOC, but you went to arbitration. That means they contacted you. So you filed your bill of complaint. I did the same. They never contacted me. So did you file like something different also, like the form of arbitration, or did simply because you filed your bill of complaint, then they contacted you?
Yeah, it was just from filing the bill of complaint that they contacted me. I think the difference too is, I've got a HELOC and I've got a mortgage, but I also have these unsecured loans. And so I figured the unsecured loans would probably be the easiest ones to knock out. And I think that's probably the case because for them, it's just, okay, $20,000 off the books. It's a huge company. It's not that much of a loss for them. It's different because it's a house that, I'm assuming that when I get to the mortgage and the HELOC, it's going to be a harder process and I probably will end up having to go to court. Yeah,
it's an ELOC, but not with like so much. It's less than 70K. So, but still, it's huge. So I was just trying to see if, is that a good sign that they don't want to talk to me before and try to negotiate, or so I was just trying to see if your process was different, but it sounds like it's the same. So I think that's it. So thank you so much. Congratulations. I hope to be in the next one. All right, bye-bye.
Every one of us.
Thanks, Frenchie. Good question. Yeah, I do believe that the debt amount is a factor, and depending on the type of property that's considered security with these documents, that's tied up. But, we will always appeal these things. And that's usually where you're going to find your remedies when it comes to mortgages and the appeals court. So let's go to Melissa. How are you, Melissa?
Hello. So on the accord and satisfaction, I wanted to ask a question with the bona fide dispute letter. So a couple of my loans have already cashed couple of the checks. So that's exciting. So I was happy to hear her process. So thank you so much for sharing that. And on one of them though, it's from the SBA and an SBA loan. And it was with United Midwest originally. And back before I found you, I was just doing my own like letter discharge thing without the trust. And I thought I had successfully discharged the loan because they came back and said that they were offsetting it, or what was the word, Chris? Do you remember? Anyway, to the Treasury. And I was like, oh, sweet. Okay. So, but now we're getting letters from SBA themselves. And it's a contractor. Like they're from, not a lawyer, but they say it's a contractor. Anyway, we sent the bona fide disputes to them. And then we got an email from one of them. It said, we have received your letter regarding the UCC lien placed on your collateral. I just want to clarify that you are requesting evidence of the SBA UCC filing. And that's all it says.
Mm-hmm, mm-hmm. SBA is really the underwriting company, and United Midwest was the reinsuring company. That's how a bond would work when it comes with the General Service Administration. So United Midwest is the actual one that's collecting, but they're really a third party to SBA.
Gotcha.
Most people who have SBAs, they think that they're paying directly to SBA, but that's not the case. Mm-hmm. So yes, you can do it, the accord of satisfaction process with whoever says, send your payments here. Do it from the very beginning of the process.
Yeah.
Dispute. You know that when it comes
and
to
that's what we started to. So now I've done that. That's what I'm doing with them. But then they emailed us back after they got the letter. And we haven't sent it.
Now, email is not going to serve as an actual response unless in that email you have an electronic certificate of service.
No, and so just ignore them then, right? On the email?
Yeah, correct.
Okay, that's what I thought. Okay,
yeah.
I just wanted to make sure.
Mm-hmm.
Perfect, thank you.
You're welcome. All right, going to Robert. How you doing, Robert?
Hey, Avery, how are you, sir?
Doing all right, thank you.
Good. I had one for you and one for Tanya. For you, I know you talk about that we could start this process at any time, regardless if our trust is in place or not. But for the accord of satisfaction document for the banks, if we are sending this out prior to our trust being finalized, would we just be speaking from the point of an implied trust like you teach us, or would we wait a certain point to do that in our trust name?
You can mention it in your bona fide dispute. How I would do it is Avery blank blank, the trust protector under declaration of, and then the name of the express trust, filed in the county of such and such in the state of such and such. Has it happened yet? No, but I didn't give a date and I didn't give an exact file number or page numbers, but I know it's going to be done by the time you get to arbitration, or if you have to go to court, it'll be done and you can show it as proof. All you do is just bring it in as an exhibit to any additional documents that you're going to file in, and there you go.
Okay, cool. That makes sense. And obviously it's a win-win scenario, because even if you put under duress and you don't even get to arbitration and they cancel that, then obviously that's a win there. I know you talked about some situations where that happened, and obviously, like you just alluded to, if it gets to arbitration, then you're pretty much, ideally will be complete by that time.
Mm-hmm. Exactly.
Okay, awesome. Thank you. And for Tanya, congratulations, by the way.
Thanks.
Where in the process did you start this accord of satisfaction with the specific creditor? At what stage were you at?
At what stage I was at in the Patreon courses?
Oh, sorry, like establishing your trust. Like, did you have everything set up, I guess, before you started sending that accord of satisfaction over?
My trust was already done. It was filed because I filed it, I think, in December of 21, and then I started doing checks to them. Oh, actually, I just have them up there. Probably as soon as I was getting into like the senior courses, then I started doing it. I'm trying to see how long ago I started with those payments.
Mm-hmm.
My first payment to them was. Oh no, I guess I started it before my trust was done. I started in August. Oh no, August of 22. That was, wow, that doesn't sound right, but I probably started it after I actually had finalized the trust, but you don't have to. I mean, I heard Avery say any number of times that you could start making those payments even before you've started your trust. So for me, I just wanted that security of knowing that the trust was actually completely done and filed, so that I could just have the strongest position when I go into it. But, you know, Avery said any number of times that you don't necessarily have to have it fully set up and stuff at the time that you kind of submit these things and submit the dispute letter and submit the accounting letter, because you have time that you have to wait after each one of those stages anyway. And had they not contacted me, my next step was to file a motion to compel, to force them to respond, and then motion of discovery. So there's all these different steps and stuff. So, you know, if I'm diligently working on getting that trust completely done and filed, there's no reason why you couldn't start this process in the meantime or congruently.
For sure. Thank you so much. And sorry, before I let you go, I just want to let you know that you're one of the quote unquote OGs that I've really connected with, because you asked really good questions. I've pretty much almost finally caught up and gotten through all of the Q&As from the beginning that you have in Patreon, Avery. And Tanya, you definitely asked really insightful questions that have helped me through the process. I'm sure you know, your questions and discussion points have helped a lot of other people. So, you know, these questions that everybody asks and are, you know, contributing to, you know, these Q&As on a monthly basis now definitely help everybody that come after us. So kudos to for that. Thank you.
Thank you.
Thanks, Robert. Thank you for that. Awesome. All right. Gonna go to Shayna. How you doing, Shayna?
Peace, everyone. Hey, Avery. Hey, group. Okay. So I had started doing the court of satisfaction process. So the last time we spoke, Avery, they ended up returning the money order back. Mm-hmm. So before that, I already did 4 paid in, according satisfaction. So what will be my thing to do now? Because they accepted and then they reversed it. And that was for January.
Mm-hmm. But all the prior ones, they didn't do anything with. They kept it, right?
Yeah, they kept that. Yeah, they kept them. Mm-hmm.
How many months of those payments did you send in that they kept?
It says, I'm looking at it now. So
2 or 3?
One. It was 4.
Okay. You still have a valid process. You have a claim.
Mm.
Even though they refund the 4th one or the 5th one, it's because they're becoming hip to it. They're like, oh, wait a minute. Now, they'll do that on that one because it's within the 90-day period, but they cannot go back and reverse the previous ones. They're done. It's locked in. So now you need to get a statement of accounting to tell them to give you an itemized statement of all of the check numbers and the amounts that was applied to principal and interest and all of that. They'll do that within 14 days for you. That's going to be your proof that they are doing what's called a breach of contract, because you sent them the first contract, which was the first payment. That's first notice. You sent them the second contract. It's just reiterating the same thing. That's the second payment, which is a notice to cure. And you did a third one, which is default, and they accepted all 3 of those. Now they're realizing we should have refunded those 3 first.
Right.
Why didn't we do that? We didn't catch it. We were greedy. So now you have to file your bill of complaint and list that.
Okay.
You got to sue.
So do I continue to make payments?
Yes, you continue to make payments, remain in honor. Most likely they're going to kick back the ones that you send in as an accord and satisfaction. So just do it regular, because in your bill of complaint, you're going to ask for, in your relief, a demand for relief, that you want all of the payments to come back to you after the 1st, including the regular online payments. All that has to come back to you because the claim is now 0 as of the 1st month.
Okay, so pay it regular, so I can pay it online basically right now.
Right
okay.
now you can do it online. Yep.
Okay. Right. Congratulations, Tanya. I'm
Thank you.
very excited for you. I've definitely taken notes as far as the confidence that you had when you were speaking to them. Avery know how I am. I'm very, very. My mind just go like ballistic when I get in front of these people. So that was very calming and humble. Thank you so much.
Oh, you're welcome. Thank you.
Thanks, Shana. Going to TJ. How's it going,
Hey, Avery. Hey, everyone. And congratulations again, Tanya. My question is, Avery, have you ever, and I have not gone through the full Accord and Satisfaction recently, again, like what you put up, so please forgive me. But have you ever done this one without sending them three of the money orders, and have you ever done it with a negotiable instrument?
No, I've never done it with a negotiable instrument. I mean, the Accord and Satisfaction, it already is a negotiable instrument, the money order that you send in. But you're asking if we've sued off of that first one before the 90 days has expired. Yes, yes, we have. And that was a case where it was continuing past 3 months. So the client continued to send in those payments in the background, and they continuously accepted.
Got
So
you.
yeah, you have to stay in honor. I rarely see it happen when you're out of honor. I rarely see it when people try to use, constructed promissory notes. It may be according to the law on how to construct it, but a lot of time those promissory notes are not insured. They're not bonded. So when it's not in that way, when the banks receive it, they see it as, so this is just an extra step that we have to do. That's not including the client's or the bank or the borrower's social security number. So they may ignore that. So that's why I say Accord and Satisfaction is the best way, because you can actually sue them on and win.
Got you. It makes sense. And the only other question I had was, at what stage, Tanya, were you at I got on late and I was in a waiting room for a little bit, but I wanted to know what stage were you in terms of your, I don't know, were they trying to sue you? Was this a mortgage? Was this I apologize. Were you in default in some way with them?
Robert had came in and asked that just before you came in. Her trust was already completed. As far as being in default, what was that, Tanya? Was there a default, or were you already in good standing? If you can still hear me, Tanya.
Yeah, I heard Robert's question. He was asking where she was in her process of
Sorry, there we go.
Oh, there she goes.
Sorry, I accidentally muted myself because I was coughing. I didn't realize I couldn't unmute myself. So no, I was not in default. This was a personal unsecured loan that I had taken out a while ago, and I had upped the loan amount and stuff as well because of a wedding, getting married. So we pulled out some more money for it.
Got it.
I was going to start with a HELOC that I had because the HELOC was actually trying to foreclose on me. And as I was trying to do that process, I kept coming back to that statement in it that, at the bottom of the bill of complaint that says that you're also stating and swearing that you are in honor with the loan amount. And by virtue of me being in foreclosure with the HELOC, I'm like, that obviously means that I have not been in honor. So I was able to actually get that rectified from a bonus from work, thankfully, at the very last minute. So then I started with this loan, being my largest payment aside from my mortgage and HELOC. Well, my HELOC's not, but the mortgage. So, yeah. So I made sure that I stayed on time with all of my payments. I might have been like a little bit late, but I was never more than 30 days late on anything. So just because I continued, even after the 3 payments, I continued to mail in my checks. So sometimes they get there on time, sometimes they get there a little bit after, or if I mail them a little late, whatever.
Right.
But
yeah, if we didn't have arbitration and we had to go to court, and this is for people who are actually in foreclosure as well, the main discovery that you are ask for is, please, I need the banker or whoever is representing the bank to please give me an affidavit saying, under penalty of the perjury of law, that they have given me the proper disclosure forms at the initiation of this loan. Can they please just say in a statement that they gave me the rescission forms that is required by law for me to have, just in case I decide to close this out? We need to make sure that this loan is actually valid from the beginning, from its inception, before we go forward with everything else, before they can do any type of judgment. If they can't give you that, then there is no foreclosure. Then you go into a different type of arbitration with the bank. Maybe they'll just reverse everything and bring you current. And then you start forward with accord and satisfaction from there. That's what I would do. If I was in foreclosure, I'm asking for a rescission. I'm asking for acknowledgement that that was given to me. Because I know in my escrow packet, when I got the loan, I got the deed, I got the promissory note, I got all of that, but I don't have any blank forms that I should have available to me to fill out and send back to them saying, hey, I don't want this loan.
Right, no one has.
No one has it. So you have to ask for it in discovery before they do a judgment.
What about after judgment? Can you still ask for that?
You should have about 20 days to appeal that. That's a writ of error.
Oh, okay. I see what you're saying. And then you said that you do this in chancery court or basically equity court. And specifically, I'm in Pennsylvania.
Yeah.
Would that be
if they're already suing you, then you're stuck in that court. And you're stuck in that court for the time being.
Right.
However, when you appeal it, you can mention why you're talking about or why you're bringing up chancery or equity. That's because you've mentioned the trust in your paperwork at that point.
Got it.
Yeah.
Got it. Makes
and
sense.
I did sue them, so they were the defendants in this situation. So I was.
Yeah, the tables were turned here.
Yeah.
Right. You sued them in chancery court.
It automatically goes to equity court for California, since she had stylized her bill of complaint to mention her trust, not just any trust. So the way you start these things, it's very important.
Makes sense. Thank you so much. And I yield. Congratulations.
Thank you.
Thank you. Good questions. All right. We're going to Vicky. How are you?
Hello. Hi, everyone. Thanks for taking the time to do this. I really appreciate it for both of y'all today. I just have a really quick question. And I could be wrong. Let me know if maybe somehow I missed it. But I know I've seen in the stuff online the bona fide dispute letter. I know there's a template for that, but have I somehow missed it? I don't remember seeing anything for any kind of a template for like the accounting letters that you send after. I'm assuming that gets sent in after you do your 3 accord and satisfaction payments. Then you would reach back out to them asking for a statement on the accounting. So you have that on record before you do the bill of complaint. Is that correct? And if so, is there a template for that?
Correct. I'm not a big fan of templates.
Gotcha.
They are, when given, they need to be used as a guide so you can understand, okay, overall what you're doing here.
Awesome.
But if you want to know the law behind that statement of according, I'm going to share my screen very quickly here. And you're going to go to UCC Article 9, and that is 210, Request for Accounting.
Oh, perfect.
Click on that. If you go down to, I believe, Section B, duty to respond to such a request, right? So a secure party, in this case, it's going to be the bank. They're calling themselves the secure party. So other than a buyer of accounts, chattel paper, payment intangibles, or promissory notes, or a consignor shall comply with a request within 14 days after receipt. So in the case of a request for an accounting, by authenticating and sending to the debtor an accounting. That's all it is. You're just asking for a statement of accounting within 14 days.
Oh, perfect. Thank you. I appreciate that.
You're very welcome. No problem. All right, so we're going to JT. You are muted.
Hello, Avery.
How you doing?
Great. Tanya, great job. Really impressive. So Avery, as you know, with your guidance, I started an accord and satisfaction process back in December with the IRS for personal taxes. And so I sent the 3 dispute letters, and I've gotten return receipts on all those. Also sent 3 restricted endorsements on 3 checks, and all of those were deposited. So my question is like next steps, but I did today, coincidentally, I received correspondence from the IRS. And basically what they're saying is we're working on your account. However, we need an additional 60 days to send you a complete response on what action we are taking on your account.
Yeah, that's very, very standard that they do that. They do that with everything we send them nowadays. Entity reclassifications, and they'll say we need additional 60 days. Then they'll either send out another one of those after 60 days has passed. Now, what I would suggest at this point, because of all the payments that you've submitted and they've cashed them, you can, I wouldn't send them a statement of accounting because there is no note or deed backing this up with them. I would go with the lawsuit.
Okay.
My personal opinion. I would actually sue with the United States Federal Claims Court. And this is what you're going to do. You're going to dismiss every single payment, every single statement date, CP 575 letter that they've ever sent you in their claim. And we're just going to use the bill of complaint to stylize this thing. With that, of course, the language in there is going to be tailored a little bit different because, like I said, there's no note. But I would sue. What's going to happen is they're going to dismiss it with prejudice, of course, just like what the attorney said in Tanya's case. And that will be an absolute guarantee of closing out any debt that you have with them.
All right. So I've gotten, and then we had those other accord and satisfaction processes. And I've also, with a car loan, I've done the request for accounting, and they sent it just the way you shared with us, where they itemized, all the ACHs. And then I went to, I stopped doing ACHs and started sending in checks with the restricted endorsements. And so that was all accounted for, but they still had the balance. But so I've prepared a dispute letter for that. And I wanted to get our monthly private client scheduled so I could just review that letter that I've already prepared. And I'll do the same thing with the IRS.
Okay, we can do that. Not a problem. Has it been at least 90 days from the cashing of those checks?
So December 29th was when, so would that be January? So at the end of March is when I'll be able to send that dispute letter out to the IRS. On the 7th of March is when I'm going to send it out to for that car loan.
Yeah. Okay. Yeah, we should have plenty of time before to catch up before you send that out.
Okay.
Yeah.
All right. Again, great job, Tanya. Amazing.
Thank you.
I'll say. Awesome job. We're going to Makisha. You are unmuted.
Thanks, Tanya, for everything you did. I'm like Shayna. I love listening to the you standing your ground. It does help. I also have a SBA loan, and the first payment was supposed to be in January, so I hadn't set up a portal or anything like that because I wanted to get more understanding of the accord and satisfaction. So with the bona fide letter, do I send that to the associate administrator, or when I log in and create this portal, like I believe the other person was asking about, you're sending it to where the payment, or do I send it to both? where the payment goes and who is on this actual loan, which is the associate administrator of SBA.
So that's a really great question. When you send out that bona fide dispute, and it's going directly to the head of that corporate charter. So that means it's going to be the president of the bank, or it's going to be the CEO or the chairman. What I want you to do is look them up with the Secretary of State.
Okay.
So find out where they are located, main headquarters. You would go to that state's Secretary of State and do a business search. You type in that name. If you don't find it there and you're dealing directly with a bank, then obviously you should go to FDIC, and you can do a bank search there, and it'll give you the address. It'll give you the name of the current officer there. You will address your bona fide dispute to him, and at that point, you should have a better sense of what your agent is. A lot of times it's kind of hard if it's, like for example, you have Exeter Finance. They are a limited liability company, and they've also provided loans for auto loans. You can easily find the registered agents for corporations or LLCs, but it may be difficult finding the registered agent for banking associations. If that's the case, just notifying the president is enough, and their corporate headquarters is enough. So you start there.
Okay, so with my actual payment, because I want to make sure, of course, that because I had
payment you send directly to the payment processing place.
Okay, and if I do the accord and satisfaction, the verbiage on that, and I'm trying to make sure I stay in honor, and they send it back.
Now, when they send it back, go ahead and pay the normal way. Just stay in honor, and you will find an opportunity to do it again.
Gotcha. Okay, I understand what you're saying. Okay, all right, thank you.
You're welcome. All right. Going to M. Day. I like that title, Nobility. The Days. How are you?
What's going on, good brother? How you doing, man?
Good. Doing good. Thank you.
Yes, sir. Congratulations, Tanya, on your W.
Thank you.
No problem. Brother Avery, I just had a quick question. So obviously I'm recording satisfied, or I have been, right? Filed the lawsuit, got everything in. The judge, so I sued basically 3 CRAs and 1 financial institution, right? The judge ended up dismissing the CRAs from the case just because they said that the trust was an improper plaintiff, right? So I'm gonna deal with that. But what I'm tripping off of is because the judge, so the summons were sent out to all defendants, right? And one of the defendants, the financial institution specifically, never responded. They didn't even appear in the case. And it's been well over 30 days, so I kind of gave them, I would say some grace because they are a United States agent, which I guess they have a different time frame, which is 60 days from what I'm understanding, to respond to any case. So I think we're coming up on the 60 days here. So just wanted to get your advice, man, on should I go ahead and just issue, that notice of motion of default judgment, or should I just wait for the court to rule on it?
Yeah, because no one is exempt from the state court rules when it comes to the timely response for anybody who's going to be a defendant. So it's always going to be 30 days. That's standard. I don't care who they are.
Got it.
But at that point, it looks like the judge is trying to find a way to kind of distract you by saying the whole plaintiff name thing is incorrect.
Yep.
What you could do is file an amendment, but it does not, not amendment, I'm sorry. When you file for your default judgment, you would structure in the plaintiff section, just put your name and then put comma and others. That way you include the trust, and the trust is going to be detailed inside of the actual statement of facts, the material facts. You want to give them, you don't want to give them everything to where they can say, oh, let's call them out on this and stall him out.
Right.
But you wouldn't have known that until you've actually just tried it and see what happened. You'll get to learn your jurisdiction. So there's no fault on your part on that.
Okay, is that pretty normal for the judge? Because like I said, they've already went over the 30 days. You know what I'm saying? They didn't even respond to the complaint, nor did they appear in any way, shape, or form. So
right, this is court. So you go back and forth with a ball. So it's the ball is now in your position. So you will go ahead and file your motion for a judgment, right? Got it. Enforce everything that you put in your bill of complaint in the demand for relief section.
Got it.
That's what you're asking for. And also back it up as to why. Mention you did not get rescission forms, failure to disclose, as to why you did the accord and satisfaction. I don't care if you didn't mention that in the initial bill of complaint, you're going to mention it now.
Mm-hmm. Okay, cool. And quick question for Tanya. Tanya, did you go ahead and file in federal court or superior court?
Superior court.
Got it. Now, another question. How are you going about setting off, the private side of the debt? I know you kind of asked or alluded to in the phone call with the attorney, and he was unable to answer that question for you, but how are you going to go handle that?
So my mentioning of that to the attorney was actually more of a tactic, because at the end of the day, I'm not actually going to be liable for any taxes because everything is under my trust. So that was just an excuse I was using to kind of backtrack my negotiations, or an attempt to see if I could get them to refund the payments that at least were mentioned in the bill of complaint, because I did not ask for that to begin with. So right. They went ahead and accepted basically my lowest offer, which was a discharge of the debt. And they did decide not to refund me any of those payments. But my excuse for asking for that was like, well, any tax implications, if they could refund that, then that would help to offset it or whatever. So that was just the conversation I had with him, even though I knew the taxes at the end of the day didn't matter. So in my case, I do have some back taxes that I owe, so I'm going to be doing this process and stuff in terms of the lawsuit against the IRS and the state to just get those things taken care of. But I've submitted to IRS and state the dispute letters and things like that, and tried discussing with them that I don't actually owe them, but the state has decided that they're going to ignore that. So I'm going to move further. But it was really more of just a negotiation tactic why I was bringing it up. I
got you. I appreciate you for that. Now, was this loan applied for under your ins legis?
Yes.
Got it. Avery, you can correct me if I'm wrong. Doesn't a discharge create a taxable event?
It does. Eventually, they're going to give you the 1099-C, whereas they're going to file the 1099-A directly to the IRS and give her a 1099-C. And when she gets that, I'll show her how to file that on her 1040s and 1041s with the trust.
Got it. Okay. I guess that was all my questions. I appreciate you.
All right. Thank you. No problem. All right. Going to Miss Ray Harrison. How are you?
I'm fine, thank you. My husband has a question.
Mm-hmm.
Hello, thank you for having us, man. It's such a pleasure and a blessing to hear you guys have these remedies and stuff like that. I had a question. I think it was pertaining to Tanya's situation. You guys are finding remedies for the banking system. I was wondering, after everything is said and done as far as remedy and getting the banks to release all of this situation, do you still stay with that bank, or do you go to another banking system because that relationship has been to where you canceled out all of the debt?
Well, they want to file this thing without prejudice, so you can still remain to have a relationship with them. Just know that they are going to be watching you if you try to do anything like this again with loans. So you can try it. Who's to say it's not going to happen again? A lot of times, the presidents at these banks, they switch out all the time. So it's very possible that you can do it again, but I wouldn't say you have to absolutely leave the bank. I don't think Tanya has a banking or savings with this type of thing. It's just a secured loan, unsecured loan. Yeah. So
because I was wondering, right? Because I had so much together, put together. I have so many, collectively, from the car loan, the mortgage and stuff like that. So I was just wondering, after doing all of the court of satisfactions, doing all of this bona fide dispute letters, what happens with that relationship? Because we're trying to build on like the EIN on the business side of it. Do we go into another bank as opposed to staying with that bank because, you know, you're trying to do these processes?
Mm-hmm. Well, it's all about, you're talking about diversifying after the fact. Right. So if you have an auto loan with one bank and you also have a mortgage with that same bank, those are two different contracts at two different times. So if you wanted to, you can do a court of satisfaction for both contracts, but that's going to be two different claims, two different case numbers. I don't think one will favor the other. I don't think that they would try to use one loan and how they, you know, let's say you lost one, but you're about to win the other. They're not going to use that win over on side A to enforce on side B, because that would be double jeopardy. So I think you're fine, but you definitely want to have multiple financial institutions set up for yourself.
Right. Okay. Yeah, that sounds good. I don't really have anything else. Tanya, congratulations, such a blessing. And Avery, your messages for your Q&As is such a pleasure, because I drive trucks and all I do is listen to you. So the Q&As is awesome. Such a pleasure.
Oh yeah, I used to do this very same thing when I was studying. You gotta absorb all this information as much as you can when you have the free time.
Okay, thank you so much.
No problem. Thank you both for coming in. All right, going to Rick. How you doing, Rick?
Hey, how you doing?
Doing just fine. Staying busy, of course.
All righty. I want to say thank you for Tanya, because so she got it right, and so it'll be good for us to go to do it. But question I've got is, there is not, or I can't, shoot. I need help getting the accordance and all that trust and stuff. And I didn't know if
well, I know that you know, you're still with me as far as our agreement together, and I got some updates for you. And I know that you know, bankruptcy was one of the issues that we were trying to remove from the credit report. And what goes along with that natural conversation is going to be looking at any type of loans that is still outstanding that we can work on as far as recording satisfaction. And I do have a question that's going to help with that.
What about credit cards?
You can do it with credit cards. Just know that it's not like they're going to close the pay the credit card to zero, where you can just continuously use it again as a revolving credit. That's not going to happen. If you use recording satisfaction with a credit card or any loan, it's complete satisfaction. It's closed. It's removed from the credit report. You would have to reapply for another credit account with that institution.
Okay.
Yeah. So if you got credit cards, and I'm not, there's some credit cards that I would shy away from, and there's some that I would use for business. And a lot of times it's good to use that. We've heard the saying that not all bad debt is bad debt. So it's good to have some. You don't want to close them all.
Right. What happens with shoot? Well, that's all right. I just had a few questions there, so I'm done.
All right. Well, I know we're gonna link up. You guys, as private clients, my link is down right now. We got some technical difficulties, so scheduling right now is going to be difficult. So I may have to just go the manual way for the next week to speak with you guys, and that's okay. And I will definitely work that out. Thank you for being patient on that part.
Okay.
Yeah.
Sounds good.
All right. I'll talk to you soon.
Bye.
Let's see. All right, I'm going to Flex. What's going on?
Hey, what's good, family? What's good, Avery?
Oh, well, as you see, we've got some good news here, and we're just on the hype train right now.
I love it, man. Keep the energy flowing. Congratulations, Tanya. I had a quick question for the bill of complaint as far as the bank account that's associated, I guess, with the plaintiff at the time. Does that actually matter, I guess, when the ruling comes around for when you get your reward, or can you set that up afterwards? I have an issue to where I don't have my trust bank account set up yet, and I was going in as a plaintiff as the trust, but I didn't know if they get the reward to the trust, how I would be able to cash the reward.
Gotcha. If there is a reward and you want them to make that check made payable in a specific name, they can put it into the trust enterprise. If the trust enterprise is open, they can put it directly into your name. If you are the trustee to that trust enterprise, you'll still be able to deposit that into the trust enterprise, right? Let's say for now you don't have that open for whatever reason. They're going to make that check made payable to whoever it is rightfully earned. So that means the name that is on the actual note with them, the name that is actually on the deed in the county.
Okay. Now, does that work the same, obviously, with other property outside of dwelling places like automobiles and things like that?
Works the same way.
Understood. Cool.
Very same way. Don't forget, rescission forms is your reasoning for discovery. Where is it? Well, yes, I'm sure we did send it to you way back when. Okay, just make an affidavit showing that you have a copy of it and send it to me.
Oh, my mortgage company sent me everything.
Exactly.
They sent me everything. So I had the rescission forms. They call it cancellation forms or whatever, but they sent all that stuff.
Good. Now that's not the only reasoning behind your recording satisfaction, you know. You don't have to have, well, in the actual bill of complaint, when you watch the webinar, we're talking about did the banks countersign your signature? They most definitely have. That's how they have to do it to get paid, right? And that's how they place you as the surety for the debt. So there's another affidavit that you can ask for. Can you please confirm that you didn't countersign my signature on the note? Two things right there. They're not going to give you both. They can't. It's impossible.
Got you.
Yeah.
You just gave me something to work on. Appreciate that, Avery.
You're welcome. All right, cool. So let's go ahead and go to James. Questions you have for Tanya?
Well, first off, obviously, I'd say congratulations to you, Tanya, for your extraordinary victory.
Thank you.
I was gonna piggyback off of a couple of quick things, Avery. One of the things that I was encountering, because I know that with SBA, I don't know if they do it purposely, but when you deal with the SBA loans, they do not allow you to send in a check. And I remember you explained the importance of that, of having a physical check. Like, they make you do everything digitally. And actually, when you do the SBA loans, they actually like shut down the portal for the most part. Like, you can go in there to see what your amount is that you owe and all that. But it makes you go to what's called pay.gov. I don't know what that is that they have set up. And also, if anybody doesn't know that's also doing SBA loans, they also had an option, I think it's for up to 6 months, I believe it is. Like, say your payment was like the $81, you can minimize your payment for 6 months down to like $25. So they have that option on there too. But I wanted to bring that to your attention. Avery, about that, because I don't know what you have to say about that, about them not even allowing you to send in a physical check.
They cannot tell you to only pay one way. I've never received a return when we had our SBA. We did a cashier's check, and we had the banker write the language that we wanted on there, and we flipped it over and wrote that other additional language, made a copy, and we sent it in registered mail. So registered mail is how I like to normally send mail because it holds them accountable, registered, restricted, and it allows me to list the amount with the Postmaster General. So let's say my payment was $500 a month for a $50,000 SBA loan. I know that they need at least $1,500 as a deposit, like you would a court bond, to turn this thing into a bond. So I'm going to tell them to insure this package for 3 times the amount of the loan. I'm sorry, not 3 times. We're going up to 90,000. I think that's the max. That's free. It's free to put on there 90,000, and that's what I do. So when by the time SBA receives it, they're already connected with the Treasury account that's with the Postmaster General. So they're not going to turn away my negotiable instrument that I turned in. And they can only maximize their profit that way. They can't maximize their profit with online payments.
Okay, I'm gonna try to show you this. How do I enable my camera? I'm sorry. Let me see. Start video. Okay, there we go. So this is what they have on their site. If it allows me to do this, let me see here. I thought.
Well, during the group settings, we're not allowing the video share or the screen share outside of the host, but we can
accept payment methods: bank account, ACH, PayPal account, debit card. Those are the only ways you're allowed to actually submit a payment, and they make you go through this website to send in a payment. That's why I was asking you. I've been doing digital payments, and I was very aggravated about the fact that they don't give you an option of payment for sending in a check. So that's why I was asking you.
Have you tried it, and have they sent it back to you?
I wouldn't even know where to send it, to be honest with you.
Yeah, like we said, SBA, like for Melissa, she had SBA, and then she also had United Midwest Bank. You have to find out who that bank is that's underneath SBA. That's where you would send it.
And that was the other.
What you can do is just write a letter to SBA with your account number and let them tell you where does it need to go. Because I don't have a bank account. I can't do it electronically. Finagle it. Let them
what if I've already done some digital payments? And that was the other thing too. I have the email confirmation from pay.gov showing that I've submitted payments too. So
I'm sure it's part of the record already, but we can't count those as accord and satisfaction.
Okay.
Yeah. Your accord and satisfaction begins with the very first cashing of the first check. That's a money order, that's a personal check, that's a business check, it's a cashier's check. You got to get one of those in.
And that was the other thing too. I think we found out, if I'm not mistaken, because one of my other associates, we were coming to you about it, and I think you had said you had done some research on it, and how they had done it was, it wasn't going to an actual bank or something to that effect. They were hiding the bank that it was coming from, or it was actually going straight to the Treasury or straight to the government or something like that, if I'm not correct, Avery. If I'm not mistaken, my bad.
Who knows? Who knows what they're doing with that right now?
All I know is I'd like to get it discharged as soon as possible, for sure. The other question I had for you was, regarding to my Express Trust, I've reached out to your assistant a couple of times. She said she would try to ask you about it. I know the Express Trust is done, and if I'm not mistaken, correct me if I'm wrong, I have a 9-8 number. I was just wondering, what is it that needs to be finalized, or what is it that needs to be done for me to get my actual paperwork for the Express Trust? I don't have that.
Right. Usually when we finalize the trademarks and licensing agreement with the SEC, All of you guys are going to eventually need that when it comes to taxes. When that's come back, then you will have your packet, and then you and I will have that call, so I can show exactly what you're going to be doing with this documentation. So,
okay. So if I had vehicles
right.
or if I got a hold of a house, then I would just reach out to you if I wanted to put it underneath the trust.
Yeah, if you finance the house, you'll have to do it in your personal name up front, and then you can do a simultaneous closing the very next day after. And I'll show you how to do that in a private call.
Okay, yeah, that's what I've been wondering for the longest, was
Okay.
about that, why I didn't have my paperwork, but I figured it was an important reason.
Very important, very important. Appreciate you, James. Thank you.
All right, thank you, Avery.
Hey,
All right,
Avery, I'm
go
gonna need to
down
drop
to-
off here.
Yes, you got to drop off. Okay,
That's all right. Yeah.
no problem.
So if anyone's got one last question, I'm more than happy to do that. But I have to head
Yeah,
out.
you are inside of the Telegram group, so they can reach you
Yeah.
there.
Yeah, absolutely. That's what I said.
All right. Thank you so much, Tanya. I appreciate it.
All right. Thank you so much, you guys. Good luck.
All right. Thank you.
Bye.
All right. So let's take a couple more. We have 15 minutes. Going to Mr. Yoda. What's going on?
I just want to throw my little penny in the pond.
Well, I saw it shimmering. What's going on?
So when Michelle was in regards to SBA correspondence that she got, what they was asking in that is for her to confirm if she was talking about her lien or whatever she put in that bill of complaint, or was clarification on did they want her to send her the information on the lien that take place on whatever entity she used to get that loan, because every SBA loan over a certain dollar amount, they apply a lien on that entity. So that's what they was asking for in that email.
Okay.
The
All right.
second thing, when Mr. Saunders, when he was just talking about, if you open up the chat, I'll put the address to where you send the checks to for the US, to the SBA when you're mailing in a check for payment.
Yeah, it's now open. You can go ahead and put that in there. James, if you're still listening, check the chat, and he'll provide that link for you. Appreciate that. Thank you for putting that in there.
No problem. And you make the checks payable to U.S. Small Business Administration.
The U.S. what? I'm sorry?
U.S. Small Business, oh, it's in there. It's on there. But that's where you send a check to, you make it payable to U.S. Small Business Administration.
Okay, got it. The U.S. Small Business Administration. That'll do. All right, he did say thank you. He got it. Cool.
All right, cool.
All right. All right, I'm going down to Alton White. How are you, sir?
Hey, how you doing, Avery? I'm doing well. I'm very new. Just really getting started. I know you said something about a Telegram. Is there any way you can put in the chat the link for that? And like I said, I'm just trying to catch up with everybody. Y'all way more advanced than I am right now, so I'm just taking it all in. So thank you.
Yeah, my
Appreciate being here.
assistant will put in the email that you can forward your user information to, and she's also going to be able to get you the instructions on how to confirm you are who you are to be able to get into that Telegram group. So just check into the chat. She'll put that in there for you. Appreciate you for joining as well. There's a lot of information, and everybody's pretty much helpful inside of the Telegram group. So if you want those that are not in it, see the chat. You'll see my assistant's email address, and she'll get you the information to join it. All right. Going to Maxine Pierre. How are you, Maxine?
Hey, Avery, how's it going? You call me Max for short, but just want to thank you for all your information and your book. It's the only book I've bought in a long time. I actually had a lot of information, but I am just starting, right?
Okay, cool.
Now, I guess I had two questions. When it comes to my birth certificate, I got my birth certificate and my letter exemplification, right? Because I was born in New York City. in Brooklyn or whatnot. So now, after I get that, I guess the next step now is to send it to the Department. I forget what Department of State, not the Department of State, because I have to get it authenticated or apostille. Do I do that in New York or where I currently live?
So you said you got the birth certificate from Brooklyn City?
Yeah, or New York Department of Health, whatever.
Yeah. Now you want to look at that birth certificate and make sure it's signed correctly by the right personnel. You're looking for the registrar or county clerk. If that signature is on there, then you're good to go straight to the New York Secretary of State. On their website, they have an authentication form. You'll print that out, you'll download it, fill it out, and they'll ask you for the country in which you want to authenticate or apostille. Do not be confused with those two words. They are synonymous according to country to country. You want to put Taiwan. Taiwan is a good country. It's a non-Hague Convention country. The New York Secretary of State will send back your birth certificate with the authentication seal. And from there, you will send that directly to the U.S. Department of State. Now, they did update their forms. We have new DS 4194 forms. Same information, it just looks different, a little bit of a color flare, but that's the final step there. Once you've received that birth certificate back, you now can take those annex security numbers that they've provided to you and start listing that inside of your non-UCC and your trust instruments, your trust minutes.
Okay. All right, yeah, I just want to make sure. So as long as that registrar has their signature on that birth certificate, then I'm good to send it off to New York State.
Yes, you can.
Okay. And I had another question about the Express Trust. Now, I'm Haitian. Well, I guess I'm from Haitian descent. But now, when you and I could actually get citizenship by descent in Haiti because my parents, are from there. Does that create like a dual citizenship or? And really, I guess I'm asking this because if I want family from Haiti to come over here, not necessarily go through the whole visa process or a normal process, could that Express Trust be used like, I guess, as a vehicle for that?
Yes, it can. There's certain visas out there that will qualify as a treaty visa, where that country has a treaty alliance with the United States. It all depends. So I'm not sure about, you said Haiti, if they're like Panama where they recognize dual citizenship, I'm not sure. But if they did, you can actually have your foreign driver's license from there and drive it over and use it to drive over here. And yes, you can use your trust. It doesn't matter which country, you can use your trust as a reason for why they're coming here to North America. What I mean by that is you would have them come in a trusteeship capacity where they are negotiating contracts, they're handling business affairs, that are going to meetings.
Yeah, I read that
all
in
of
the book, yeah.
Yeah, so that's a B1, or you can do an E2 visa.
Okay. So as long as it's pretty much, they work here or they have some property here, they pretty much have the Express Trust that they could travel through that visa.
Right. Mm-hmm.
Okay. And all right, well, I am just starting with all that. Getting this process started, but hey, I thank God for you, man. Definitely put a lot of this stuff in chronological and common sense order. So thank you.
Oh, you're very welcome. My pleasure. Great question. All right, so we're going to Ronnie. You are muted. Ronnie G.
Hello, everyone.
All right.
Can you hear me okay?
Yes.
Okay. I just had a question. Thank you for this, everyone and their questions. I may have missed this, but I was just wondering if you have How many people can quit claim a property that's in a living trust, which gives the property or the units to 7 children? Can one of the 7 claim their units to put it on their quit claim deed or their percentage?
No, they would not be able to do that. You would need the entire trust to do that. But you can take your equitable interest. You're going to have to turn the volume down on the computer.
Sorry, the echo.
Got a little reverb there. Let's say you have 20% in that property and everybody else has 20%, 30% or whatever. You can list that 20% in your paperwork to go ahead and at least get your non-UCC and your trust filed in your county, but you will not be able to do a quit claim deed to your trust for just the 20%. You can't do that. If that makes sense.
Can you hear me? I'm sorry, for some reason my audio went completely down. I heard nothing.
Oh, I'm sorry. Whatever percentage that you have in that property with others, you can list that percentage in your trust to get it recorded in the county. But you cannot do a full quit claim deed from them over to your trust solely. That will not work. They would have to give all of their equitable interest over to your trust to do that. Okay.
Okay.
Yeah.
Great, thank you. And then is it possible to ask another one about a reverse mortgage?
Reverse mortgage? Sure, go ahead.
Okay, if you have a reverse mortgage, can you try to how can you get your title and owe nothing? Like, is it possible to do an accord of satisfaction for that?
You can do an accord of satisfaction for it.
Okay, okay.
What I
It
would
would be
do
the same process?
Yeah, it would be the same process. What I would do is obviously that reverse mortgage is most likely in a personal name sitting in the county right now. You can still quick claim it over to the trust.
Okay.
And then begin the accord of satisfaction payment process.
Okay.
Yeah.
Awesome. Thank you so very much.
Mm-hmm. All right. We're going to Miss Correa. You are unmuted.
Hi, thank you, Avery. I am so grateful. I'm actually just enrolled in the freshman class.
Mm-hmm.
And one of the questions that come up for me when we're doing the title of nobility and looking at our history. So I am Native Hawaiian, part Native Hawaiian. Is there anything, because of the illegal overthrow with the Hawaiian Kingdom, is there anything that you would suggest as part of this process? I've done my passport. I just submitted to the U.S. Secretary of State my apostilled birth certificate.
Mm-hmm.
But I just wanted to know if you have any insights into that, because I'm told that it's a dual jurisdiction.
Mm-hmm. Yeah, it was an island, so very different from the acquisition of the Mariana Islands under Rule 144. However, Hawaii has still succumbed to the Cession Act, CSSION. So you're still looked upon as how, the country of California was before it became the state of California. It's the same thing as all the other 50 states. So what we do in the other 50 states or the 49 states is going to apply to you as well.
Okay.
So it's going to be the same process.
Okay, so it's still treated like a republic.
Yeah, it is. I know.
Okay. I just wanted to get clarification about that.
Mm-hmm.
And then also, are you still accepting private clients?
We will be in the month of May. That's when, so if you have an inquiry about it, in the chat here, you'll see my assistant's email. Just send her an email about it, and we'll get you the proper agreements in May and have that call with you to kind of go over what that looks like.
Okay. Thank you.
Okay. You're very welcome. All right. Jay Smith. Jason, is that you? You are unmuted.
Yeah, yes, Avery. Hi, how are you?
Doing good. Good to hear from you. How are you?
I am well. I'm on my iPad. I couldn't figure out how to get my name changed on there, so I apologize. I just had a quick question. In one of the Patreon courses, you were talking about when a bank account gets shut down, and the abandonment laws and how the bank claims on the 1099 OID. Can we eventually claim that like on our taxes instead of the bank claiming it, if that makes sense?
Only through an actual lawsuit. And it's very difficult because okay, your trust is not a banking institution.
Okay.
You're going to have to go to the bank to get it done. And the closest thing to the bank for you in this position would be the local courtroom, the Superior Court. Okay. And it's only going to take place inside of insolvency court, which is filing for bankruptcy. It's the only way.
Okay.
Yeah.
Okay.
I don't really condone it. I don't think it's something that's worthwhile.
Okay. Yeah, it just fascinated me that, and I did have that in the back of my mind that they had some special privilege or whatever because they were a bank.
Mm-hmm. Exactly. And with bankruptcy, it's something that can be done every 7 to 10 years. So you would have to have a record of that accumulation of 7 to 10 years of the checks and all of that. But the banks are going to do it with every 3 years without bankruptcy, you see? So you're going to be saving records, but at the same time, they're going to be rescinded and recouped by the banks every 3 years. So they've really set up a system here where that's just not something I'm going to fight.
Yeah. Okay. I understand. Yeah. It's really unbelievable. When I came across that, you talking about that. So.
Yeah, it really is. I mean, the banks in downtown, they have the biggest buildings for that reason.
Yes. Yes. All right. Thank you so much.
You're welcome. All right. Going to, I believe this is Dwayne. How you doing, Dwayne?
I'm good. Thanks, Avery. Can you hear me?
Loud and clear.
Okay. I have a question about contract infringement. You've mentioned that in one of your videos, and you go through the definition there. I'm an authorized dealer for a copier company, and I have a security agreement with them. And my question is, would my promissory note that I file in the county take precedence, or would it infringe on that contract that I have with them? It's like a line of credit that I can get their products every month and then pay them once a month.
Right. So the best way to do that is, and you're talking about the lien that your trust has on you, which is the promissory note.
Correct.
The best way to do that is if you record that down in the county on your non-UCC and then reflect it at the Secretary of State level on a UCC-1, you will then be able to do a debtor search. That's called a UCC-11. The Secretary of State should come back and it should say that you owe X amount to the trust. Now you would take that as a dispute method, and you would send that directly to the lender who's that you have a contract with to show first in line, first in time, because the Secretary of State has just provided you evidence that only you owe to the Express Trust and not this bank. So that's how you would do that. You would have your lien to stand higher than theirs. They're supposed to register all loans that they do with the Secretary of State, but they don't do that because there was never really an initial loan that came out of their vaults.
Right. Yeah, I did a UCC 11 earlier, and nothing is on my name.
Mm-hmm.
So the contract with this manufacturer isn't there. So I was just worried that if I did this other lien against me, does it infringe on that contract? I'm afraid of losing my dealership is kind of what I'm getting at in that respect.
I see. move forward with the court of satisfaction to get rid of it.
To get rid of the security agreement?
To get rid of the loan that you have with them.
Yeah, I don't have a loan with them. It's a month by month line of credit, if you will.
Mm-hmm. Do you want to keep it?
Yeah, I want to keep my dealership.
I believe we have a student here, Jesus. He's got a dealership as well. And there is a certain line of credit that you would utilize to purchase the cars. And of course, you sell it within a certain amount of time. I can imagine that would be something that you want to keep. But when you say you've actually done the debtor search, did you do that prior to you filing your lien in the county and with the Secretary of State?
Yeah. Yes, I did.
So that's why it's not going to show. So you will want to do those 2 steps first before you go back and do a UCC 11 again to actually have that record.
Okay.
That proof.
Okay. Do you have time for one more question?
Sure.
It's about the DBAs. In that video that you have, there's 6 DBAs that you have listed there, and 2 of them are with LLCs. Well, I don't have an LLC. I'm a sole proprietor.
Mm-hmm.
So what do I do with that?
It would be just your Express Trust doing business as your name.
Okay. And then the Express Trust Enterprise doing business as my name?
If you like, you can do that. You don't have to, because usually you're going to set up the First Trust Enterprise bank account with yourself as the personal guarantor, as the trustee. So you're still, at that point, you're doing business in that trust ID. So, I mean, you can do it, but you don't have to.
Okay, you kind of cut out there a little bit. I missed some of that, but.
I was just saying you can do that. You can list it inside of your DBAs if you want to, but you don't have to.
So how many DBAs as a sole proprietor would I have?
You would have your Express Trust doing business as first, middle, last name.
Okay.
Express Trust doing business as last, comma, first, middle. Express Trust doing business as first, middle, family of, last, estate.
Okay.
Express Trust doing business as first, middle, last, bankruptcy estate, just in case.
Okay.
First, middle, I'm sorry, and then you have Express Trust doing business as the trust enterprise. And you're going to have the Express Trust doing business as your title of nobility name. From there, if you have LLCs or corporations, you would list those as well. So that is a lot when it comes to doing that on the county forms. So what I'm recommending is, and I'm going to show this in the version 2 of the course, is to list all of them in one affidavit.
Okay.
Get done with one document. It's going to be listed in one affidavit.
In Montana, they only file at a state level, these DBAs. There's no county level DBAs that we do.
Exactly. So that's why in the counties, they do accept affidavits. So my method of how we get around that, you do the affidavit, you get it notarized, and then you send it directly to the local newspaper, and they will circulate it in the local newspaper. After that, they're going to give you a certified copy of that, and you take that down into your county and record it there as an affidavit. You don't record it as a DBA, it's recorded as an affidavit in the miscellaneous section. And then your affidavit with listing all of those DBAs is going to be good forever. There is no 5-year or 7-year timely limit, whereas the forms would have that timely limit.
Okay. All right. Thanks, Avery. I'll yield. Thank you very much.
All right. Thanks, Dwayne. Michael, what's going on? You are unmuted. Michael, are you there? Carlson. No. All right. Going to Jesus.
Hello.
There we go. 1 second, Jesus.
Hey, sorry about that. It didn't automatically unmute.
I gotcha. How you doing?
So, good. I had a quick question about the Express Trust Enterprise when it regards to LLCs.
Mm-hmm.
With that, does that become the single member? Is it the enterprise or is it the regular express trust? That
Yeah,
becomes
the regular
let's say, the
express
single
trust.
member. The regular, not the enterprise.
The regular express trust would be the single member.
Okay.
You can then list yourself down as that manager. Of course, that's updating their articles of organization. Now, if you want
Right, which is different for each state.
Very different, very different.
Yeah.
Yeah. So taking it, if you want to connect that to the trust enterprise, as long as you have that LLC registered, it's active, and you also would need to register the trust enterprise with the Secretary of State as well. When you go into the bank, now you're opening a personal business account. I'm sorry, a business account, not personal. This is a personal trust account. You want them to list your LLC down as the actual trustee. And so the only way they're going to do it is if the trust enterprise and the LLC is both registered with the Secretary of State. That's all they care about.
Okay. And is that something that I should be doing on my own, or is this being done as a private client?
As a private client, I can do the updating of the articles, but actual walking it in and doing that wherever you are,
right,
be on you. Yeah,
I can do that.
Yeah,
no problem.
Yeah.
Okay. And then I know that we were unable to connect Thursday. Is there a way that you and I can connect this coming week to go over the email that you had sent me with all the list of things that need to be done?
Yes, we can. I have about 7 people that we got to do that for this week. So you are on that list. So I'll reach out to all of you guys at the end of this call to structure the time and what's best for you.
Awesome. Thank you. Appreciate it. With that, I yield.
Okay. All right. All right. All right. Going to Abdullah. How are you, sir? Just gotta unmute your mic. Abdullah Muhammad. No. Just gotta raise the volume a bit, and then we can hear you.
Can you hear me now?
A little bit. I can make out what you're saying.
Okay. Well, okay. Yeah. Of course, I'm new. I just kind of jumped in. You guys seem to be ahead of me, but I was my specific single out. My question would be that I got my 98 number like in 2021, and my 86 number as well. That's for the banker's EI. So that's what it was called when I got that. Hello?
Yeah, I hear you. You got the 98 and you got the 86 EIN.
Yeah. Okay, so because I had that when I was looking at your classes, I started in the sophomore, but I'm now thinking, should I just have started in the freshman? Because I was wondering, like, I noticed I've learned a lot more back then. When I got this, I didn't know what the next step was. Do you think that the time for me do I need to do that stuff all over again, or do you think I can just start with what I have?
Well, I don't know what specific information you use to get the 98. Sometimes people are coming from a different school of thought. So what I would recommend is to go back into the freshman and just to, dot your I's and cross your T's to make sure you've done everything correctly as far as title of nobility names and the express trust name and all of that. And that will lead you into the sophomore class to show you if there is a slight difference to the EIN numbers that you have versus how I would suggest you go about getting them according to the IRS manual. So it's always good to go back, even if you may have a lot of these processes done from a different school of thought. Sometimes you could have missed something. It's very possible. So please always go back just to double check. All right, good question. I'm gonna go to Jesus. What's going on?
Hello.
Hello.
Happy Saturday, Chief.
You as well, thank you.
Go ahead, go, say hi.
Hi, Avery.
Hey there. Good to hear from you. Are you almost finished with the book?
Hi, Avery.
He said, are you almost finished with the book? Tell him you've been slacking. You've been good.
Yeah, I'm almost finished.
Wait, you loud.
Yeah, I'm almost finished.
Good. Stay with it. Pretty soon we're going to be hearing from you in this course here online. What's going on, Jesus? What's going on?
All right, guys, go over there. Hey, Chief, real quick. So I was doing my job with the Oprah and all that and trying to get the oath, and I went everywhere. Government Records Council, Superior Court, clerk. I ruffled a lot of feathers, and I spoke to someone who was very rude to me, but I like that. And she pointed out for everyone here in Jersey, Apple 2481. Once again, Apple 2481, Chapter 59. They passed a law in 2015 that they don't have to disclose the actual oath that a judge signed. So I went and I looked at it, and it's public law, and I was just like amazed by it. What they can do is provide full name, title, and date that they signed it. Now that's cool. So anyway, I'm talking to everybody in the county and the city hall, and then the Superior Court clerk, she was like, "Oh yeah, I know that judge very well. Why do you want that information?" And I go, "I want to know her too." And she goes, "For what? Who are you?" I was like, "I'll be whatever you want. I'm an independent journalist. I'm a tax-paying citizen. It's public information." And so she brought that up to me, and then I looked it up, and just like that, man, they don't have to disclose it.
So remember I said that the courts are the banks?
Yes.
So that means that the oath is held with the comptroller of the currency. And the only way you're gonna get them to get it is by court order. So you would have to file something that judge has done against you where he's violated the oath. And then you're gonna ask for discovery of him presenting that actual order, which is gonna come from the comptroller of the currency. So you have to CC, now you have to add another party to the case. But you already know that even if you do all that, they may still not give it to you, even if you did proper due process. What do you want to do with it when you get it?
So check, well, if you're doing the trivia thing, I want to read it thoroughly and to see where does their allegiance lie. And you said before that they sometimes are the stunt dummies for the higher ups.
Mm-hmm. So you're dealing with an administrative judge, which is a stunt dummy. And he's got a judicial counsel above him. It's kind of like he's Judge Judy, basically, right? So he don't really have an oath like that. He just is an authorized representative. So you don't really need it. Now, what you can do is just say in your affidavits who you are, as far as your nationality and your right to that according to your birthright, right? And that you are one of the people, as stated in the preamble of your Constitution, that you accept all judges and trustees and all agencies that they hire at their oath to defend your state constitution and the U.S. Constitution. And if they defend those two things, that means they have to defend all of the documents and treaties that exist before that. That's what I'm gonna say.
Yeah. I'm not even stressing it. I got the ace up my sleeve to tell you right now. You know, no government shall intervene within a private contract that is in already existence. So I got their oath through all like the laws. So I know what exactly you signed, right? Damn, I'm losing my train of thought. So I don't know what I did. I ruffled a lot of bro, a lot of feathers over there. And yesterday when I got home, they switched it over. Because remember I told you the lady goes, oh, I know her very well. I go, okay, I want to know her too. It's just public information. She didn't recuse herself, but I got a letter yesterday when I got home and whatnot. The doorman was like, oh, you got a letter here, blah, blah. They switched it. Now I'm not going in person no more. And it's a video conference again. And now I'm going against a judiciary clerk. 1v4. Yeah, so I guess I'm doing what I'm doing the right way, and I'm ruffling and I'm standing my ground, because when the lady goes, oh, per this law, I said, okay, we're gonna do this because you seem very upset that I'm asking you stuff. I'm gonna email you a request for the oath of allegiance / to take the bench or whatever, and deny me in the email. She goes, okay, do it. And what are you gonna do with it? I said, I'm gonna forward it to the Attorney General. And I don't know what I did. This was like 5-6 days ago. I don't know what I did, what I said, but yesterday when I got home, they switched it over. So now I'm not going in person. I went and got a nice suit and everything. So I'm not going in person. And now it's video conference. And now it's, I'm not going to say the person's name, but it's Jane Doe. And the title is Judiciary Clerk 4, Roman numerals, IV. So Judiciary Clerk 4. So I'm gonna chew on you now.
Now this is child support case, right?
Correct.
Okay. Who is your accuser?
Baby mama.
Okay, she's the one who started everything?
You got all the paperwork.
Do you most likely think she'll be in that Zoom call?
100%. She was in the last one. And she said, oh yeah, my name is this, that. And then when it came to me, so I said, are we on record 3 times? And then I said, notice. So, oh, you know, I did my whole 0% lingo, and that's when they hung the phone up on me.
Regardless if you have it in person or on a Zoom call, do you know what your discovery would be from her?
She don't got no discovery.
She has nothing to give you to substantiate.
What's the question you asking me properly, so I can answer you properly? What's the question?
The question is, if you're in court, with in person or over the phone, what discovery are you asking from her to agree to pay monthly child support? What could that possibly be?
Motion for discovery. Where's the contract where's the promissory note that I even a part of this?
Exactly.
Ooh, nice.
Exactly. Whenever someone's going to ask for money from you, there would have to be a contract to prove that. And they have to prove that they actually gave you something so that you can pay them, right?
Yeah.
That's just the easy thing about it. And so now you know that the state is trying to get involved in that to where they can get a little bit of money too.
Pillage my village.
That's pillaging.
Yeah.
Yeah.
I got like everything down. I'm just waiting on you and I to just connect and everything, but I'm holding it down on my end. And like I told you, I guess I ruffled a lot of feathers for them to transfer it, because the lady goes, I know her very well. So everybody knows I'm looking for this judge oath. And now I'm gonna do the judiciary clerk, and I'm gonna do the same thing I did again. And y'all could keep sending me letters, and every 2 or 3 months, I'm gonna keep getting on the phone with y'all and keep telling y'all, no, you don't have jurisdiction. And it's not like I'm a deadbeat, like sending her money.
Exactly.
You just heard my daughters, both of them, talk. I get them every weekend.
Yep.
I send their money. So it's like, we gonna keep, you wanna ride this roller coaster for longer? I like roller coaster.
You're doing good. You're doing good. Stay the course. Stay the course. Anything that you receive in the mail, you will definitely send an affidavit of denial and serve everybody. And you stick to that, where there's not enough.
To my primitive understanding. You breaking up, Avery.
Hold on. You're the only one with the evidence, because you're going to be the only one sending in affidavits of denials to everything that the court sends you and everything that she would send. And so then it becomes a case of preponderance of evidence. And that's how you're going to win. Just prevail through it. I know they're going to play their monkey games, of course. And you have to see through that. You don't need to get frustrated with it. That's just the game.
No, I'm not frustrated. I'm actually learning all.
Yeah. Good.
It's only like a summons. It's for a paternity hearing. and last 2 years pay stubs. So they're not directly saying, oh, this, that. So to the primitive understanding I have of the situation, we're gonna do the writ of injunction and motion for discovery to nip it right there. The affidavit of denial, I have a couple templates. You know, I could just do that.
Yes, sir. Now I got a court trivia question for you.
Oh, I love trivia.
They sent you a summons, which is a word that's synonymous with warrant. What goes with a summons?
There's no verified complaint attached to it. So right there, that they're in the wrong right there. That lacks due process, and then that falls into the lack of subject matter jurisdiction, lack of due process.
Everything under Rule 12, basically.
Yeah, I did good right there, right?
Be good.
And I ain't got no notes in front of me. I'm talking to you, just that shit rolling off my tongue.
Exactly. You got it.
So I get a free consultation.
Good one. Good one. You won't even need a consultation after what I just heard.
Yeah. I'm on my grind, Avery. I'm not these respectfully. Oh, Avery. No. Listen, you're busy. People gotta understand that. So I'm on my grinding. And big shout out to Minister Day. Big shout out to Don Trust. You know, big shout out to a couple people in Flex, the real MVP. I'm on my grind, Avery. I'm just waiting. I'm gonna call you out a little bit. I'm just waiting for the little template writ. When you busy, when you're done with everybody with your privates.
Gotcha.
I'm on my grind though, Avery. And I just wanted, once again, for the Jersey people in here, it's gonna be very hard to get an oath. Per Apple 2481, Chapter 59. They literally passed that law. You know, just FYI.
And we know that is an ex post facto law.
Which goes against the Constitution, but they're not practicing Constitution in that APA court system. So I got to change venues and get up out of there. And then, you know, so we on this roller coaster.
Yeah, that's good. You letting them know that we're out here.
We out here.
Yeah. Appreciate it. Thank you, man.
Enjoy your Saturday, brother. I'll hear from you soon.
Daughter's going to be at the point where she's going to be training her youngins too. Awesome. All her friends.
Take care, brother. I appreciate you.
You too. All right, you guys, we got to stop it here. We're going a little bit long. If you guys have additional questions, please put them in the Patreon messages. I'm going to check them before the day is over today and answer them there. So this was recorded. We will be sharing it. And I will see you next first Saturday of the month in April. Don't forget private clients. I will see you all again on the 15th of this month with a few of your representatives. And we'll talk about anything and any question that you may have, which you're prospecting to do. So I look forward to that. Once again, thank you, Tanya. Congratulations. See you guys next time.